Hello, how are you doing? Hi, hope you're doing well. Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. For our returning subscribers, I thank you for always stopping by to check what is new on the channel. For you who is watching us for the first time, we encourage you to subscribe to the channel, join the big family, improve your practice, become a better lawyer, become a better law student. We have content that are of high value to help you become the person you desire to be. That's a high flyer. So today we are looking at legal adumbration, key steps. In court, most times there is room for you to adumbrate. What do I mean by adumbration? To explain, to succinctly in within a short time to explain to the court the content of your written argument. You see some people argue, it's only senior lawyers that have that privilege of being given time for adumbration. See, what matters is your approach to the court. Don't learn only to just adopt your process. Learn to also adumbrate. The reason you go to court, stay back even after your matter, is to see how other people do their practice or do their work. Adumbration is one of the keys that can help you elucidate your point to the courts. As much as the court will tell you, I will read it, but it is advised that you always ask for. My Lord, may I humbly ask to be given a minute or two to adumbrate on the points highlighted. Even though the judge might ask you, whatever you want to say, is it not contained on your address? Sometimes just to save time, that's why the judge will ask you that question. So that if everything you're going to say is contained in your written address, I'm going to read it. So why waste the time of the court? It's also important that as much as you have done your legal agreement in form of a written address, it is not so bad to get other cases that maybe they did not enter into your written address that supports your argument handy. So that peradventure the court asks you, okay, is what you're going to adumbrate on, is it not what is in your written address? Because my Lord, there are a few cases I stumbled upon after I have filed my process, and I wish to let the court know about it to help my argument. So that way the court can allow you for a 1 minute or two to adumbrate. Now, it's important you start with the interesting point first or the highlight, because sometimes the court will be bored if you're repetitive. It's important to also know that if you don't know how to argue within a short time or to make your point clear, the court may not have that patience to wait. So now, adumbration can come in form of an interlocutory application, like you filed a motion, you find the preliminary objection, where you attach the written address to your application. And your written address is your legal argument with respect to that point you're trying to canvass. You've written it is in a format form because we are in the era of front loading. And you feel, my Lord, I need to highlight it. I need to bring the attention of the court to certain issues. Sometimes it is say when something is repeated, it makes more sense. So it's good that some points you highlight it to the court. Unless that court is the court that does say adopt, I'm going to read everything. Sometimes I might even tell you I'm going to read, I may not end up reading everything. Some other time, you know, if you can, always seek for time for adumbration. But also note that if you don't utilize your time well, the court might cut you off. So the key facts or the key steps you need to understand is in adumbration, start with the highest point or with a striking point. What is that thing in your argument that stands out, that seeks to bring to your favor the ruling or the judgment of the court? What is that angle? What is that argument? You start with that. What is that argument that push to rest the issue at hand? Start with that. Do you have a Supreme Court case that have settled issues that you're arguing in similar forums, in similar circumstance? Start with such argument. Now, in adumbration too, it's time to distinguish what the other party have written and from what you have written, and you try to bring out the juice of the substance of the case to say, my lord, this is just where the contention is. The court will be very interested to listen to what you're saying if you're making sense. Try to pick your words, practice what you want to say before coming to court. You're being given a file just to go and adopt a counter affidavit. You just flip through, just counter affidavit of 6 paragraphs. My lord, it was good to do that. But going further for excellence, going further as a lawyer who knows his or her onions, you'll be able to look at the written address. What is the argument? For example, someone is arguing that the court should not amend the process, should not grant leave for amendment to the other person's process because what the person has introduced as an amendment is shifting the case or changing the nature of the case. Now, in your adumbration, you are going to let the court know, yes, amendment can even be granted before judgment. But where the amendment seeks to change the nature of the case, it is not allowed. That's one of the exceptions. That's one of the exceptions. So you start from that highlight that this amendment this person is seeking falls under the exception. And because it falls under the exception, these are the cases that have supported that in times like this, the court should refuse amendment because it's going to be prejudicial to the other party. My lord, granting this application means that you are allowing the claimant to change, or the defendant to change the nature of their case from this to this. And my lord, it's more about, shooting the defendant on the leg. My lord, it will bring injustice. My lord, it will no longer serve the interest for which amendment was what stated or provided for. So you're going to hit it. So it's not when you start to rehearsing what the facts that are well known, but hit the main point on why the application should be refused or why the application should be granted, depending on the side you are and depending on the argument you have provided in your written address. So it's good to know what is the high point in my argument. It helps your adumbration. Are there new cases you found that is supporting your case? Good. Are there new principles of law that have arisen or that have been, that have been made that you need the court to know? New cases, new authorities. In your adumbration, you let it, you bring it out for the court to see. Can you summarize in any time you were going for an adumbration? Try and summarize your address in 5 minutes. That is the key. All you want to say, can you say it in at least 5 minutes? After 5 minutes, no matter who the judge is, they begin to run out of patience because there might be interjections in terms of the other party saying, my lord, I need to respond. These are new issues. And so can you catch the attention of the court for at least 3 minutes, 4 minutes of your time? Then you round up because most of the things you want to say also is address. Save that you have maybe few things to add here. So adumbration gives more life to your address or your written argument. But you must master the art of adumbration in the sense that you start with the high points, start with those new cases, bring out the juice of the argument. What is this thing that the court should to determine? What is this cross of determination? The issue for determination between the argument of the two parties. What is that? So hit the point. If you feel you have a higher reasoning on why the court should tilt in your direction, hit the point. And when you hit the point, you make your case. And, when the court is writing that ruling or the judgment, it resonates with the judge. Like, the judge can even hear you the way you spoke in court that day. Another thing that helps in adumbration is being confident in the position you're in. Many a times people are making sense, but the manner in which they're presenting their case does not even suggest that they're making sense. You cannot be sluggish in your argument. You must be firm, look in the eye of the court, and make your argument. Put in the right tenses, make the right constructions, and no project your argument succinctly. Do not make it look like you don't know what you're saying. You're just flipping through books. Let what you want to say be summarized on a plain sheet or your tablet or your just in front of you. You don't need to start opening. If you want to refer to a document, know the date of the document, know the name of the exhibit if it's already an exhibit. So say, my Lord, and know where the paragraph it was what stated at paragraph 6 of our counter affidavit, where the exhibit is a certificate number or that's a document of 18th June of 18th February. My Lord, that document speaks for itself. We ought the court to look critically at the exhibit attached by the defendant or exhibit attached by the three, which states clearly the position. So, in making your argument in an adumbration, you must be what firm. Don't look confused. Know what you're saying. Provided the court asks you certain questions that might want, stand firm to defend your position. Because when the court asks you one or two questions and you're not able to answer it brings doubt in the mind of the court. So don't see that adumbration is only for senior colleagues. You as a junior lawyer has that right to adumbration. If you politely, the most, you know, you know, calm way, seek the indulgence of the court to allow you in 2 minutes, just adumbrate. The court may want to know what exactly do you want to adumbrate. Hit it. My Lord, just to let the court know on the recent decision of the Supreme Court is so and so. My Lord, the contention in this application is, the way you speak and draw the court's attention to you. The court will be looking at, this young lawyer is so bold. This lawyer is speaking boldly. Even if the court might feel you're not making sense, but your manner of approach, the way you're presenting the argument, gives the court that attention that, will even make you can even exceed their time. But in all adumbration, make it a rule that I should not exceed 5 minutes. Whatever you're saying should not exceed at least 3 to 5 minutes. Some judges may not give you that luxury of time. But for senior lawyers, senior advocates, sometimes 10 minutes they are doing the argument and all of that. And also note that in some adumbrations, new issue may raise new issues or law, which will make the opposing counsel to feel he has a right of reply. But based on the judge's discretion, the court can allow that person to reply based on what you have said. So adumbration gives life to your argument. So at every point in time you have an application, don't just prepare to just adopt. My Lord, I adopt a counter affidavit, and in line with the rules of court, we file the written address. My Lord, we adopt this as an argument in this with respect to this application, and we urge the Lord, like the court, to enter or to dismiss the application of the claimant or defendant, or just depending on what the prayer is all about. You also seek, my Lord, I crave with the indulgence of the court humbly to just adumbrate on few issues in 2 minutes. The Lord will give you. So your approach is important so that the court will not regret giving you that opportunity. Always be prepared, even if it's not your matter, you're holding brief for someone. Try to know the facts of the case, try to know the core of the application you want to move, try to know the storyline. Don't just go to court because you're going to court. Don't just do things because in this easiest way. Try and go the hard way too. Adumbration, it takes someone who knows what he or she is saying to adumbrate. So always, show yourself as someone who is qualified, ready at any time to take up. Your presentation matters a lot, and it helps. During the time the ruling will be written or the judgment, your argument will keep re-echoing in the ears of the judge. It's a subconscious thing. So adumbration is good. Don't run away from it. If you can, if you're prepared, seek for the leave of court to adumbrate on your issues. It gives it life. It helps you speak as a human beyond the letters on the process. The adumbration gives life, it makes more sense to the court of what your argument is all about. And it also helps your confidence. It helps you to grow. It helps you to speak to the court without fear, without jittering, without being shy. It helps you as a lawyer. So, friends, adumbration is key. I encourage you. The next time you're going to court to argue an application, prepare to adumbrate. It will help you. Be it your written address, be it your final written address, be it a normal interlocutory application, be ready. If you have any have any, please drop on the comment section. We will respond to it. There are wonderful, over hundreds of videos on this platform that have been put together to help you become a better lawyer, to help you attain excellence in practice. So I encourage you, please check our channel. Just sit down, relax, get your popcorn or your drink, go to the channel, listen to them one after the other, and you'll be sure that value is only what we are giving. We're not compromising, we're giving premium value to help you become that very best lawyer, law student that you desire to be. If you have any question that may not be related to a topic here, still drop a comment. We will see it and we'll respond to you. The idea behind Lawyers Info Hub is to contribute our quota to the growth of legal education, to the growth of advocacy, you know, for law students, for young lawyers. You just want someone not to be covered with ignorance. You're having an issue with a topic, you can come to our channel, look for solution. What can I do in such situation? And the answer pops up. We are not hiding our knowledge. We even invite others to share their knowledge, all aimed at helping you to become a better lawyer, a better counsel, a better law student, a better advocate, better in-house counsel. So, friends, we appreciate you. If you're yet to subscribe, please do hit the subscribe button. I keep thanking everyone who is watching, who will watch later. Thank you. We do not take your presence for granted. We really, really, really appreciate you. You're the reason why we are here. We thank those who have supported by subscribing and those who will subscribe in the future. We really love you. We appreciate you. And we know that what we are doing is bringing value to you. Do take care of yourself. I know that you can always be the best. Don't let people pull you down. You may not be where you want to be, but surely with resilience, with tenacity, you can get to where you desire to be. You can be the best lawyer ever in your area, in your jurisdiction, in your field. It's nothing difficult in attaining that height that you desire to get. Just be at it, keep pushing, keep preparing, keep showing up, and before you know it, you'll be there as you desire. Then take care and be the best version of yourself.